Hello, good morning, everyone. This is Rakesh, and welcome to the lecture series organized by Tiwari and Associates in conjunction with the Punjab and Haryana High Court Bar Association. Today, our session is on the Insolvency and Bankruptcy Code 2016. And today, we have with us one of the most leading and eminent senior advocates of the Punjab and Haryana High Court, who specializes in commercial and corporate litigation, Sri Anand Chibbers. And joining him is Advocate Mr. Abhimanyu Tiwari. And before I hand over the session to the panelists today, I would just like to outline the procedure to ask and interact with the panelists subsequent to their lectures. In case anyone has a question, there is an option here where to which a particular person can raise their hand. So anyone who wishes to ask a question or interact with the panelists is requested to kindly raise their hand, subsequent to which I shall be unmuting them and they can directly ask the question to the concerned panelist, and after that the panelists can answer that question. Any other queries they have, they can also use the chat option or the question option, and anything else we'll see as it goes. So with that, I am now handing over the session to Mr. Amitabh Tiwari, who will hand it over from him.
Good morning, everyone. Before we get into the entire insolvency code and the section and the legal part, which I'm sure sir will be able to explain in a better manner, I would just go into the reason why this act was brought into force. As all of us know, that the code was brought into force in 2016 by the government of India in order to solve, revive and reform the banking and the financial sector. During that time, there were a lot of NPAs in the country which were running into lakhs of crores of rupees, which were plaguing the country. And this code was brought in to solve that problem. This code seeks to consolidate Yeah, am I audible now? So yeah. I'm audible? Yeah, so I'm sorry, there was a technical glitch. The code seeks to consolidate the existing framework and seeks to amend all the previous acts. And the entire list of the acts is given and provided in section 243 to 255 of the code, read with the schedule. Now, this code has around 255 sections and 11 schedules. It encompasses within itself the insolvency of corporate guarantors, personal guarantors, corporate companies, in personal insolvency, and it's a one-step solution for all the insolvency problems of the country. It was brought in also to protect the interest of the small investors and to project India as an investment destination. To give some stats, I would suggest that once this code was brought into was notified, in the insolvency rankings, India's ranking went up to 56 from 108. In terms of recoveries by the various creditors, the recovery rate went up to 44 to 45% from 26%. And the time taken to resolve the company and to get the company back to its to get the company back on its feet, the time taken now is 1.6 years on an average as compared to 5 years. So the code is still evolving. There's a lot of jurisprudence still coming in, and we hope that the code will be able to meet the objective and the reason for why it was brought into the picture. Now, the code, like I said, the code has amended a lot of acts. Recently, the personal guarantors were also brought within the ambit by an amendment in 2019. And before we get onto the judgments, which we will discuss later on, I would now ask Sir, who, as everyone already knows, who is the leading lawyer in the IBC in NCLT Chandigarh and in Delhi. Before that, I would just like to give a vote of thanks to Sir, because in 2016, before all the important judgments came into the picture, the jurisdiction of the state of Haryana was with NCLT Delhi. And the NCLT Bar Association had filed the case, and it was argued by Mr. Chibbard, which culminated in the transfer of jurisdiction of the state of Haryana to NCLT Chandigarh. which was a big deal, and it gave all of us a lot of opportunities to help in the evolution of this new act. Now, sir, I'll give it to you, sir, to explain the act and to give a brief overview on who can apply, what is the resolution plan, and how does the act actually work in practical terms.
Good morning, everyone. And first of all, as everyone is facing this COVID-19 pandemic problem, I hope everyone is all right, everyone is safe, and best wishes to you for your health and your safety. Stay at home and of the usual things, maintain a little bit of distance, etc., etc. But all of us, as professionals, as lawyers, are undergoing an extreme difficulty sitting at home, not able to perform our work, our duty, legal profession. Well, let's hope that is over as fast as possible. Some kind of a vaccine comes, or we get into some herd immunity, whatever they leave it to the professionals, the doctors, whatever they want to do best to save humanity. In any case, now I want to start with my lecture. I want to thank the Bar Association of the Punjab and Haryana High Court, as well as Mr. Abhimanyu Tiwari, Mr. Amitabh Tiwari, and Mr. Rakesh for organizing this webinar on IBC and overall purview of what is it all about. Well, let me tell you, as on date, of all the legislations, of all the acts, of all the courts which are available and in place in this country, the National Company Law Tribunal has one of the largest of the jurisdictions, one of the most important court, a court which has been given power to decide issues which were earlier available to special courts or special tribunals, a consolidated forum where a resolution process of corporates and companies and soon of individuals and partnerships be taken into account for the resolution. So before we start on what is the National Company Law Tribunal, Insolvency Bankruptcy Code, just 2 minutes, let me give you a brief background of how all this came into operation. Earlier, the jurisdiction of companies and corporates was with the high courts of the states. The high courts had jurisdiction of companies which had the registered office within the territorial jurisdiction of that particular high court. The high court was governed to have original jurisdiction as far as Companies Act 1956 was concerned, of issues of winding up, of issues of merger, demerger, of issues of operation and mismanagement. Subsequently, in the early 90s, the issue of operation mismanagement was taken out of the purview of the High Court and transferred to a special tribunal called the Company Law Board, which was about 5 of them in the country. So as far as Punjab, Haryana, Himachal, Chandigarh was concerned, Delhi was concerned, they went to the Company Law Board in Delhi. Similarly, Bombay had one, Calcutta had one, Madras had one, of a lot of states combined together. Then the issue remained in the High Court was only of mergers, demergers, amalgamation, etc., which were under Section 391 to 394 of the Companies Act 1956, and the winding up of companies, which was under Section 433 to 439 of the Companies Act 1956, which stipulated only one thing, that if a debt of more than 500 rupees was due and payable, and that debt was admitted, you could straight away come to the High Court, paying a nominal court fees, and say the company is unable to pay its debts. The court, without really going into the merits, demerits of any disputes, etc., was only concerned whether there was an amount which was due admitted. For example, there was a promissory note, a negotiable instrument, a check which had bounced, amount shown in the balance sheet, a letter written by the director, etc., anything to show that the amount was admitted was good enough for the company to wind up the company. Once the company was ordered to be wound up, then the only remedy remained was liquidation. That means the official liquidator attached to each concerned high court, consolidate its assets, consolidate its creditors, sell the property, distribute the money as envisaged under sections 529A to 530 of the Companies Act 1956. But subsequently, the government had a second thought. The government realized that there was no point in liquidating and selling the company for only its land, building, and machinery as scrap. They decided that to imbibe the Western law evolved, American, English, and some other countries, where the insolvency resolution of companies was taken to be the foremost concern to consolidate a code which would not only entail the liquidation, but prior thereto, to resolve the resolution of the company. Let it stand on its own feet. Let the company be able to function again. Let the company not be dissolved and liquidated only on account of if there was any default, or in case there was any debt or any liability which was admitted. Now, prior to coming up this Insolvency Bankruptcy Code, how this code evolved was that in the year 1992 to 1995, etc., and subsequently in the year 2002, various acts came into the Indian system. The Recovery of Debts Due to Banks and Financial Institutions Act 1993, the Securitization Act in 2002, which allowed banks to file petitions in the debt recovery tribunals, the banks to take over the asset of the company, mortgage secured with it under the Securitization Act by just giving a notice of 60 days, etc., etc., and then basically taking over the asset and again selling it in the open market, in an open auction, as per procedure prescribed. But there was never an insolvency resolution of a company to bring it back on its feet. And therefore, taking in view all these issues, the Insolvency and Bankruptcy Code was brought into place and notified on 1st of December 2016. The National Company Law Tribunal was constituted. Basically, the Company Law Board was transferred into the National Company Law Tribunal. There were 11 tribunals constituted in the country. Each tribunal had jurisdiction of various states. Like Mr. Amitabh has already told you, Haryana went to Delhi. We filed a writ petition, which was allowed. Haryana came back to Chandigarh. So Chandigarh NCLT has jurisdiction of companies which have the registered office in Punjab, Haryana, Himachal, Jammu and Kashmir, and Chandigarh. So 5 states jurisdiction on union territories is with the NCLT at Chandigarh. We have one bench headed by a judicial member and one a technical member. Basically, a bench comprising of one bench of 2 members deciding cases under the Insolvency Bankruptcy Code, as well as under the Companies Act, now notified under 2013 Act, which also has jurisdiction of cases of operation and mismanagement, as well as cases of merger, demerger, and amalgamation, which are the exclusive domain of the National Company Law Tribunal, which is known by 2 names of cases which are adjudicated under the Insolvency Bankruptcy Code. The tribunal is known as the adjudicating authority, and cases which are decided under the Companies Act 2013 are heard by the National Company Law Tribunal. Now, cases of operation mismanagement and merger demerger under the Companies Act 2013 have taken a little backseat, which we can discuss a little later. And insolvency and bankruptcy court cases have taken a priority because they are time bound. They're time bound as per the code. They're time bound as per have the resolution process within a particular stipulated period of time. So the cases which are now listed before the National Company Law Tribunal are both under the Insolvency Bankruptcy Code as well as the Companies Act 2013. Now, coming straight with this background of things to the Insolvency and Bankruptcy Code, which came with effect from 1st of December 2016. There were three categories which were formulated under the Insolvency Bankruptcy Code to trigger the mechanism of the Insolvency Bankruptcy Code for the purpose of resolution of companies, and which were bifurcated if there was a debt and if there was a default by one, that is A, by a financial creditor, which could be secured, which could be unsecured, and in today's law, as held by the Supreme Court and amended by the Insolvency Bankruptcy Code, home buyers are also termed as financial creditors under Section 5, subsection 7 of the Insolvency Bankruptcy Code. They could straight away, in case of a default, file a petition in the NCLT, having jurisdiction of the company where the registered office is, to trigger the insolvency process, or as they call the Corporate Insolvency Resolution Process, CIRP process. Now, I'll come to the process a little later. First, as I said, is a institution of or triggering of the code by a financial creditor, which is under Section 7. The second triggering of the code was by an operational creditor. An operational creditor, described in simple parlance, is one who provides goods and services to a corporate debtor, and the corporate debtor does not pay that amount of the goods and services provided, and there is a debt and there is a default. So the corporate debtor can also face insolvency if a resolution process is instituted by an operational creditor, which is under Section 9. And the third is by the company itself under Section 10 of the code, where the company, subject to fulfilling various conditions that it is unable to pay its debt or there's a default, can itself come and file a petition in the NCLT, having jurisdiction over it for a resolution process. Now, under the Insolvency Bankruptcy Code, the resolution process could be instituted by the financial creditor, the operational creditor, and the company itself. And the end result and the subsequent thing, what happens once the petition is admitted or the company has to undergo a CIP process, is all the same for all the three mechanisms, whether Section 7 of a financial creditor, Section 9 of an operational creditor, or Section 10 of a company itself, where on the petition being admitted, the National Company Law Tribunal appoints an insolvency resolution professional as an interim measure, and subsequently, when the Committee of Creditors is constituted, to finally appoint a resolution professional, basically undertaking various tasks and duties, which I will just subsequently elaborate, for the purpose of the resolution process. Now, to trigger a petition, the first phase, a Section 7 by a financial creditor, 9 by an operational creditor, 10 by the company. The first phase talks about filing a petition, which is to be decided now, in view of the provisions of the Insolvency Bankruptcy Code, within a stipulated time of maximum 14 days, even though it's directory by various Supreme Court judgments now, but still the mandate has been given, the statutory provision is there that you have to decide within 14 days, subject to any objection by the registry or by the NCLT, which has to be rectified in the 7 days, but the court has to decide the issue within the stipulated time of 14 days or whatever, as expeditiously as possible. Now, the problem over here is because of filing of so many cases and so many litigations that the court is a practical difficulty, is unable to decide the case within the stipulated time of 14 days, but it does decide taking the cases to be a priority case and taken up first in the cause list and decided as fast as possible. Now, for a corporate debtor which has a default on behalf of a financial institution, whether secured or unsecured financial institution, there is no defense, which I thought when I got the first case was pretty strange, because how can you not have a defense to say whether the petition should be admitted or not admitted? Subsequently, as the law evolved, there are certain defenses which I will explain. Right now I'll explain. But otherwise, all that the court had to see, the Section 7 petition has to be filed in form number 1 as per Rule 4 of the rules and regulations, and the forms as prescribed under the Act, which we will not go into. All of you can have a look at the rules, regulations, and the section, statutory section itself. It said only two things: if there is a debt and there's a date of default. Now, for example, the date of default for a financial institution is a date when the account becomes a non-performing asset. For a financial institution, a bank which gives loan and you don't service the loan for 90 days, as per the RBI guideline, it becomes a non-performing asset. Now, that is the date, the triggering date, or the date of default. Now, that has to be filled in form number 1 in part 4 to show the date. For example, the date of NPA is the date of default. And therefore, the petition has to be filed under Section 7 within 3 years, as envisaged under Article 137 of the Limitation Act, which has now been explained in 7 to 8 judgments of the Honorable Supreme Court, and of course followed by the National Company Law Tribunal, National Appellate Tribunal, that for the purpose of triggering a CIP process by a financial institution, the default has to be within 3 years. If the default is not within 3 years, then it can go to any other remedy, like go to a National Debt Recovery Tribunal, etc., or under Securitization Act, because where the limitation is about 12 years, because the debt is secured asset, it is governed under Article 62 of the Limitation Act. So for the purpose of Section 7, the petition has to be filed when there's a default. The date of default, it has to be 3 years. There's no defense. The court invariably, in almost every case, subject to accepting the objection about limitation, subject to accepting the objection that part payment has been made, subject to an objection that the matter is being settled, which is in rare cases, or an OTS is in operation, does admit the petition, and immediately the insolvency resolution professional is appointed. The board of directors are suspended. They have no control on the working of the company, on the finances of the company, cannot deal with the assets of the company, cannot deal with the clients of the company. All they have to do is to deal with the insolvency resolution professional. Now, coming now to Section 9. Section 9 allowed a defense. Unlike Section 7, where there's no defense, like limitation, or if the petition is not in conformity with the Form 1 of the Insolvency Bankruptcy Code, Section 9 petition by an operational creditor allowed a defense, and that was a substantial one. The defense was, if there is a dispute, which has been described under Section 5, subsection 6 of the Insolvency Bankruptcy Code, that there was a suit or an arbitration pending before the filing or sending of a notice under Section 8(1). I should have explained it earlier. To instigate or to institute a petition under Section 9 by an operational creditor, the prerequisite is that you have to send a notice under Section 8, subsection 1 for 10 days to the corporate debtor to repay the amount which is in default. If it is not paid, or a reply comes and which does not show that there is any dispute, the operational creditor can file a petition under Section 9, of course, again within 3 years, as per Article 137 of the Limitation Act. Now, the defense which was available to a corporate debtor at that point of time was that if there's a dispute, and the dispute is if there's a suit and an arbitration pending. But the law evolved, judgments came, and the Supreme Court finally came to a conclusive conclusion in the famous judgment of Mobilox versus Caruso, that in spite of the fact that there is no suit and arbitration filed prior to the sending of the notice, but from the analogy of various facts and circumstances and documents on record, it is shown that there is a dispute. Then the only remedy for the operational creditor is to go and file a civil suit. Now, what was that? Which was not a suit and arbitration? For example, an operational creditor provides goods and services, it sends X amount of material, and there is a plethora of mails or some documents or letters or some, in today's world, the WhatsApp messages, etc., to show that the material supplied was not of good quality, and that the corporate debtor had raised a dispute that he had not received the material, or the material received was of not good quality, or the material which you had sent was not within time. So there's a dispute, and therefore, in view of that judgment, the court said, irrespective of the default, if there is a semblance of a dispute which can be seen more than a naked eye, then the only remedy is to dismiss the petition and send it back to the civil court to decide whether that amount is actually due and payable. So it was a kind of a blessing in disguise for genuine corporate debtors who are, as you know, as we end the discussion, we'll talk about the problem which we face today, is that that was a blessing in disguise for them to raise an objection, at least, which was not available under Section 7, as I'd already said. And therefore, Section 9 allowed them to take a defense when the petition was filed on Section 9. Notice was issued by the NCLT. You could file a written statement, take the objection. Then the court had to come to a conclusive conclusion whether there was any dispute, whether there was a default. In spite of the fact there's a default, if there's a dispute by a suit and arbitration, or through, as an example which I've already explained to you, in view of the judgment of the Honorable Supreme Court. The third remedy was when the company itself knows that it's going through a dilemma, it's going through a problem, there is a recession, the payments are not coming, the banks are not restructuring the loan, the banks are asking for too much of the money right now, the banks are threatening to take over the assets, that they could also themselves apply under Section 10 if there's a default. The court, after taking the petition under Section 10, sees that the company is unable to service its default, can then also admit a petition, appoint an insolvency resolution professional. Now, in all the three mechanisms of Section 7, 9, and 10, ultimately, the appointment of the insolvency resolution professional and subsequently the resolution professional is which is triggered and followed. What the code also did was enact another section, which was an important section, Section 12 and Section 14, which said that the complete process, it cannot be a never-ending, unending process. The resolution process under the IBC code has to be quick. So under 12, there were timelines fixed, which were mandatory, which has now been said in the Supreme Court in the latest judgment that there's still a discretion left with the NCLT to extend it in special circumstances. But the timeline was 180 days, 6 months on the date of admission of the petition under Section 7, 9, or 10. The IRP or the RP has to complete the process within 6 months. Another 90 days time was given subsequently as per amendment, so the time worked out to 270 days. And thirdly, another amendment came in 16th of August 2019, which said it could go up to 330 days. and 330 days is the last date by which the insolvency resolution process has to be complete. If not, then the court in special circumstances could extend the date. But what is the most important? 330 days, less than a year, almost 10 months, 11 months is the time, is the date when the company comes into CIP process. That is the date when the court passes an admission order. 11 months thereafter, the resolution process has to be complete. And then there was section 14, which talked about moratorium, which was akin to section 22 of the Sikh Industrial Companies Act 1986, which said that moratorium of the company till a resolution process is complete or till the time the liquidation is ordered, there will be no suit or proceeding filed against the company, for or against the company. There was a complete ban or a status quo or a stay granted by the court that no authority could even initiate any recovery mechanism, including taxation authorities, including banks, financial institutions, including a process of securitization, including a process of taking over the company by the bank. So all this was stayed till the time the resolution process had to be complete as envisaged under section 12, 330 days. Now comes what happens and what is the process after appointment of the IRP or the RP. The basic thing is that the Insolvency Bankruptcy Code formulated a mechanism for the resolution process under the code, and as has been held by 4 Supreme Court judgments from SR to Swiss Ribbons to Innovative and 2 more judgments, that the final and the last authority to decide upon the issue of the resolution process is with the creditors and a special class of creditors, that is the financial creditor. The financial creditor is who has to see what is in the best interest for the resolution process of the company. So the IRP or the RP, within the time as prescribed under the Act, which is very short, 30 days or so, has to invite claims from all the creditors of the company by giving publication in newspapers. That's a duty which is envisaged to him under section 17, 20, 21, etc. And then the creditors file a claim before him, and he bifurcates the creditors into financial creditors and operational creditors. The financial creditors constitute a committee which is known as the Committee of Creditors. The Committee of Creditors is the final authority for the purpose of insolvency resolution process of the company, subject to a decision, an arbitrary or a wrong decision taken by them to be rectified by filing some kind of an application in the NCLT. But otherwise, even the NCLT's wings have been clipped for the wisdom or the financial decision of the Committee of Creditors. Now, what is the process the Committee of Creditors has to do? What it has to do is the resolution professional, or along with the wisdom of the Committee of Creditors, gets the company valued, prepares the information memorandum, publishes in papers, calls from eligible resolution applicants or like a bidder as per the earlier act, who have to fulfill a certain criteria to come and give a resolution process for the insolvency process, resolution process of the company. Meaning thereby that once the information memorandum is published, people who are interested to come and take over the company by giving a resolution plan, which is put to the Committee of Creditors, who in their wisdom see if it is good or it is bad, pass by a voting majority of 66%, and then give it to the resolution professional, who subsequently would file a petition in the NCLT for acceptance of the resolution plan. That is the final process as per what the maximization value, what the what the preamble of the Insolvency Bankruptcy Code is, or what the government wanted to do. Once the petition is filed before the NCLT, it sees that the plan is good, it is in the interest of the financial creditors, it is in the interest of the operational creditors, it is in the interest of the public at large, it is in the interest of one and all. Finally, passes an order under Section 31, sealing the process of insolvency, discharging the resolution professional, and directing everyone, one and sundry, in this country, including bankers, taxation authorities, government authorities, individual X person, Y person, that the resolution plan is binding to one and all. And that is the final process as envisaged under the Insolvency Bankruptcy Code. The Committee of Creditors, therefore, has been empowered to take the final decision for the best interest of the corporate debtor. It will take a decision on behalf, for and behalf of all the stakeholders of a corporate debtor, including the operational creditors, who would also be paid a part of the bounty which is received from a resolution plan, and that would be binding upon them. Subsequently, they are not allowed to file any further suit for recovery of the balance amount. That's over and out. That's it, the finality under Section 31. In case a resolution plan is not acceptable to a committee of creditors, or the timelines as under the code of 330 days are over, then there is no other option for the resolution professional but to file an application in the NCLT for liquidation. And the liquidation is the same process as was under the old act. Sell the property of the company, distribute the amount received as stated on Section 53 of the IBC code, that is to the firstly to the secured creditors and workmen, and then to government dues, etc., to lastly to the operational creditor, that is unsecured creditors. This is the basic fundamental of the IBC code. This is a basically overview of the IBC code, what it wants to do, what the government wanted to do. It has a non-abstante clause. It overrides all other enactments. You cannot say that if a suit has been filed under the recovery, or a original application has been filed under the DRT under the Recovery of Banks Debts Act, or an action under Section 13(4) has been taken under the Securitization Act, all these are subservient. They are overridden by the Insolvency Bankruptcy Code. Nobody can challenge a decision or an order passed by the Insolvency Bankruptcy Code, by the National Company Law Tribunal. Any person who's aggrieved under the Act can file an appeal before the Appellate Tribunal, which is only one, which is in New Delhi, called the National Company Law Appellate Tribunal. And an order finally passed by the National Company Appellate Tribunal can be taken to a second appeal, which is the Honorable Supreme Court. Now, this being basically the purview of what the Insolvency Bankruptcy Code is there. But my view, just 2 or 3 more minutes on some issues which I feel is that the second appeal, which is now going to the Supreme Court, should be allowed to be taken and heard by the respective High Court, by a division bench of a respective High Court. The Supreme Court is already too much overburdened with cases from all over the country. A final verdict can be taken by the Honorable High Court in a division bench, and then only on a very important substantial question of law can a matter go to the Supreme Court under Article 136. That is one of the views which I feel I have, which I should be implemented. Secondly, even though earlier there was a complete bar for a erroneous or a perverse or a wrong order to be challenged before the High Court in a writ petition under Article 226, was the view which was being taken that since there's an alternate remedy, to file an appeal before the appellate tribunal. That should be the only remedy. But now, in view of 2-3 judgments of the Honorable Supreme Court, like in the case of Embassy, and one more, if there is an order which has been passed by the NCLT which is without jurisdiction, or an order passed by the NCLT which it could not have been passed, or an order passed by the NCLT to entertain a petition which it does not have the jurisdiction to entertain, can always be taken to the High Court in a writ petition under Articles 226. And that is, I think, very important and very good, because that is where the law has to evolve. That is where the constitutional powers of the High Court cannot be fettered and taken away. The High Court has to oversee and has the power to oversee all the tribunals under Article 227, and therefore the power where any fundamental rights or an erroneous or illegal orders are passed by tribunals can always be taken to the High Court in 226, even though there is an alternate remedy of an appeal. So this is the basic purview, which I wanted to talk about the Insolvency Bankruptcy Code. Amitabh, you have any more questions or anything, you can just your voice is not coming.
So has already spoken about major judgments. I would just like to add a couple more which have recently come in. Initially, when I was practicing myself, we all under the code, we all have to file a no dispute affidavit, as everyone knows, under section 9(3)(b), irrespective of the fact if we have received a reply or we haven't received a reply from the corporate debtor to the demand notice sent by the operational creditor. But now the NCLT in Sangeeta Goel versus Roydek India Chemicals Private Limited has clearly stated that only in a situation where the corporate debtor within 10 days of the receipt of the demand notice has not sent the reply to the operational creditor, then only an affidavit to that effect can be submitted in the code. Otherwise, it is not required. In addition to that, another very important judgment that has come is regarding arbitration and the code. Initially, there were operational creditors who, because of an award in their favor, were filing Section 9 petitions in the NCLT. But now the Supreme Court has clearly said that if a Section 34, that is, objections to the award, are currently pending before a civil court or before the appropriate forum, in those cases also, it is no longer an undisputed debt and a Section 9 cannot lie. So with all that, now I want to just open up the seminar to some questions, and if anyone has any questions, do let us know, and so that we still have about 10 minutes and we can then ask, sir can answer those questions and we can take it forward. So Rakesh, if you have.
Yes. We first of all, thank you, sir, and thank you to both the panelists for the very elucidating elaboration on the code. We do have a lot of questions. We are connecting Mr. Sarthak Bharadwaj, who has a question. So we're connecting him to ask his question right now.
Please go ahead.
Mr. Sarthak Bharadwaj, yes, you have been unmuted.
Hello. Hello, sir. Sir, am I audible?
Yes,
so am I audible?
Yes,
right.
yes.
Thank you very much for your lecture, sir. I truly gained a lot. My question was with regard to the arbitrational proceedings, sir. So if there is an arbitration agreement which was in existence long before the Insolvency Code was formed, what happens to that mechanism of dispute resolution? Are the operational and financial creditors still allowed to seek recourse under the IBC due to Section 238 of the code, or because the very aim and objective of the code is for a quick dispute resolve mechanism, should arbitration proceedings also be given some sort of a primacy? Because I mean, is there any recourse for the parties to go into arbitration rather than the IBC code?
Let me explain to you. Arbitration cannot have any primacy, according to me. Arbitration is a mechanism evolved out of a clause of an agreement between two parties. So for a person to invoke a remedy by filing a civil suit, etc., he invokes the provisions of the arbitration agreement and files a Section 11 or a mutually accepted arbitrator to decide the list or a dispute between the parties. Now, there are various judgments of the Honorable Supreme Court, which we can elaborate later on, which basically say that the arbitration is a remedy which is only between two parties. It does not resolve and decide the larger than life issues, for example, of winding up, or now under the Insolvency Bankruptcy Code. So arbitration proceedings, if continued, have to be immediately stopped under Section 14 of the Insolvency Bankruptcy Code, or if there is an award, it cannot be executed in view of Section 14 because the resolution plan is not per se to one person or to one individual or to one party who has an award in his favor, but it has a general mechanism for all the creditors at large, which is basically the preamble of the Insolvency Bankruptcy Code. And therefore, according to me and according to the judgments which are now available, arbitration does not have any primacy over the Insolvency Bankruptcy Code. Section 238 non-abs ante clause is a complete answer in that respect.
Thank you, sir. We now have another question by Mr. Ankit Sharma. We are connecting Mr. Ankit Sharma. You may please ask your question, Mr. Ankit. Okay,
Hello.
it
Hi,
looks
sir.
like we have lost. Yes, yes.
Yes. Hi, sir. How are you?
Good morning.
I just have a small question. I just want you to throw some light on the amended Section 4, where the default amount has been revised from 1 lakh to 1 crore. And is it prospective? And has the amendment somehow made the act spineless for small business houses, according to you? I just want some expert opinion on that, sir.
Yes, I should have answered. I should have said so in my opening thing. Just now that you put it, let me just explain to you in 2 minutes quickly. See, as per the old Act of 1956, when you had to institute a winding up against a company, the figure which was the basic figure was ₹500. So when the Insolvency Bankruptcy Code came into operation, the government in its wisdom thought that the Insolvency Bankruptcy Code Section 7 or a Section 9 can only be instigated and instituted if the amount which is in default or a debt which is there is ₹1 lakh or above, subject to increase up to 1 crore. So from 1st of December 2016 till date, till about a month back, the amount which was required to instigate and institute a Section 7 or a 9 petition in the NCLT was ₹1 lakh. But now, in view of the present circumstances and in view of the unfortunate situation where I think all business houses are completely closed and they're facing an extreme financial distress, the government in its wisdom has sought and thought in the interest of medium scale MSME industries that the amount should be escalated to pass the basic qualification to 1 crore. Now, 1 crore is the amount which is to be an amount in default for the purpose of filing a petition under Section 7 by a financial institution or by an operational creditor. Now, according to that, 1 crore is prospective. Now, the problem, and just to elaborate on the question that you asked, is that what about the cases which have already been, which are pending and which have been filed and which have not been taken up for hearing during the time when the courts are basically closed, subject to a very urgent hearing through video conferencing or virtual hearing? What about them? Well, those questions are being asked to me by, if not a large segment of my clients, and we propose to make the legal submission in the court that if the IBC threshold of 1 crore is now for any future litigations, those people whose litigations or whose petitions are already pending have also gone through the same pandemic problem, and therefore the proceedings of qua them below 1 crore should also be suspended till the time the government notifies it again back to 1 lakh. And also now, as we are hearing, one more thing which I must tell everyone who's for their knowledge, that the government is already contemplating to suspend Section 7 petitions to be filed by a financial creditor, Section 9 petitions to be filed by the operational creditor, and Section 10 petition to file by the company for another 1 year. That ordinance is already, they're waiting for the ordinance subject to all the approvals, and which is going to come very soon, because they were waiting till the last date of 30th of April. According to me, it should be now in next 10 days time or 1 week's time, that they're completely suspending Section 7, Section 9 and Section 10. And now then would be an important issue for the question which you already put was, what would happen to those petitions which are already pending? Now there are substantial number of petitions pending. So if you're suspending everybody to for undergoing a CIP process of Section 7 by a financial creditor, 9 by an operational creditor for 1 year, so why not suspend all the cases which are already pending, which according to me also would be taken up in courts and to higher courts for a final adjudication. They should also be suspended, because you cannot differentiate, you cannot classify differentiate between equals, according to me.
We now have a question by Mr. Rishabh Raj Singhania. I am connecting Mr. Rishabh. Hello, Mr. Rishabh. We seem to have lost the connection to Mr. Rishabh. In the meantime, we have another question by Mr. Anuj Malhotra. We are connecting Mr. Anuj to ask his question.
Yes,
hello, Mr. Anuj.
Yes, good afternoon.
Yes.
Yeah. Sir, I wanted to ask regarding the overlapping effect of RERA and IBC. If an allottee wants to institute a insolvency proceeding against the promoter,
yes.
so what would be the overlapping sections? And
now, in view of the latest judgment passed by the Honorable Supreme Court, the home buyer or a allottee could invoke either the Insolvency Bankruptcy Code, could go under the provisions of the RERA, could go under the Consumer Protection Act, either of the places. But in case of a petition filed under the Insolvency Bankruptcy Code and a CIP process is ordered to be instituted, that means an IRP or an RP is to be appointed, then all those proceedings in the RERA and before the Consumer Protection Code or any other court would deem to be stayed till the final resolution process. Because no individual, as I said earlier, like in arbitration, can benefit by taking a recourse to a remedy available in any other act. They cannot have precedence over the complete hierarchy of creditors, because the basic principle what follows under the Insolvency Bankruptcy Code is pari passu, meaning thereby, for example, there are 5 financial creditors of a corporate debtor and CIRP is instituted by one of them. He cannot subsequently get up and say that since I instituted the CIP process, I should be given precedence and my complete amount should be given. What the court will see and what the RP will do will be to see that the complete committee of creditors are paid in pari passu terms. So therefore, a home buyer can initiate RERA. Supreme Court allows you to do that. You can go for Consumer Protection Act. Supreme Court says you can do that. You can invoke IBC, but IBC will have primacy.
I would just like to add a bit. The judgment sir is talking about is the landmark decision of Pioneer Urban Land, wherein they upheld the validity of the Amendment Act to include the home buyers. And in that judgment, it's very clear that that RERA has to be read harmoniously with the court. It is only, like Sir said, it's only in the event of a conflict will the court prevail. As of today, a home buyer can even go to the ICO under IBC, can go under RERA, can go under consumer protection. But as per my understanding, and I think Sir can interject here, in IBC, a person cannot ask for refund of the amount. Only the prayer which an lottie can ask for is for the CIRB process to begin against the home buyer, against the promoter or the real estate company. Whereas in RERA,
Amitabh, you're right. The distinction and difference is that all these acts have a different jurisdiction, a different power to grant a relief.
yes,
RERA has a power to grant a relief of return of the amount deposited by the allottee. IBC doesn't have that power. IBC talks about a resolution process of a cooperative. We're talking about entirely different things.
yes,
But the non-obstante clause in section 238 overrides the RERA Act and the Consumer Protection Act. For example, there's section 3 in the Consumer Protection Act. A lot of consumer courts, national company law, the national tribunal under the Consumer Protection Code said section 3 has a power that all other acts for the time being in force, meaning they said that as a primacy or overriding effect over all other laws. That's not correct. That's not what the Supreme Court has said in the final judgment by Justice Mathur.
all right.
We now have a question by Mr. Rishabh Singhania. We're connecting Mr. Singhania. Mr. Rishabh Singhania. There seems to be a problem with that. Yes.
Rakesh, did he mention the question or has he typed out the question?
No, he wanted to ask a question. No, he's not away. There's a connection problem. We are connecting Mr. Ashwin Vardarajan, who wanted to ask a question. Mr. Ashwin Vardarajan, you're connected. Yes.
Yes. Good afternoon, sir. So my question was that in the Supreme Court decision of SR Committee versus Satish Kumar Gupta, they had held the word mandatory under Section 12 to be manifestly arbitrary under Article 14 of the Constitution, primarily for the reason that resolution or the litigators in the NCLT have a tighter or a stricter timeline which they have to face, which is somewhat different from what litigators face in other courts, let's say a High Court, Supreme Court, or a District Court. So what are your views on that? Is it actually that tough for litigators to function in the NCLT, and is it actually justified for the Supreme Court to hold it to be manifestly arbitrary in violation of Article 14 of the Constitution?
Validity of the Act has been the judgment which you're talking about. Committee of Creditors of SR versus Satish Kumar Gupta, right? That came on. I have the judgment in front of me. It came on 15th of December 2019, right? And the judgment, which has been passed by the Honorable Supreme Court, upholding the validity of the Insolvency Bankruptcy Code, that is in the case of Swiss Ribbons, has come on 25th of January 2019. And both these judgments have to be read harmoniously together and take into consideration whether a particular act is violative of Article 14 of the Constitution or not. But if we read both the judgments together, we find that the Supreme Court, in its wisdom, has said and thought that the Insolvency and Bankruptcy Code is a complete code in itself, and therefore the interests of all one and sundry are looked after. This is according to this thing.
Thank you. Now we have another question by Ms. Deepika Singla. We are connecting Ms. Deepika Singla to ask a question. We have connected you. If you're audible, if you may ask your question now. Ms. Deepika Singla. There seems to be a connection problem again. We have another question by Mr. IP Singh. We're connecting Mr. IP Singh. Mr.
Yes,
Singh, yes, you're audible now.
yes,
Please ask.
yes. Good afternoon.
Good afternoon, IPG.
My question is, what are the rights of landlord to claim rent or eviction due to non-payment once the liquidation has been ordered by the NCLT?
The rights of a landlord, lessee, have been taken note of in various judgments passed by NCLT, NCLAT, and the Honorable Supreme Court. The amount which is to be claimed, now let me explain to you. For example, a corporate debtor has taken up premises on lease, and the company gets into a CIP process. In case the resolution professional continues to occupy that premises and use the corporate debtor as a going concern, this comes under the CIRP cost, which has to be paid in priority to any other claim, to a secured creditor or even to a worker. Otherwise, any amount of lease to be paid to a landlord would come in liquidation to be paid under review of section 50 in the hierarchy of the payments to be made. So therefore, in case the company is in liquidation, then the amount has to be paid to the landlord only if the RP is using the premises for the purpose of continuing the corporate debtor as a going concern. Since the amount is to be paid of some pendency of some lease money, then it has to come to be paid under section 50. So it all depends on facts and circumstances of each case. Now, there are a lot of cases where the property which has been taken on lease is continued to be run by the IRP till a resolution process. That amount of money of the lease to be paid till the time a final resolution plan is passed under section 31 is the CRP cost which has to be paid in priority to any other debt.
So I think there is also, I would like to state that there are certain judgments passed by the NCLT now, which have actually held that landlords are no longer operational creditors and the lease rent which is to be paid is not an operational debt. In this conundrum still needs to be solved by the Supreme Court. So only then will we be able to really enter and answer this question that Mr. Singh has asked in a better manner. So I think
there are many issues which crop up every day. For example, since the time the Insolvency Bankruptcy Code has come into operation on 1st of December 2016, there have been more than about 50 to 60 amendments. The act is changing. The views are changed by different courts, expressed by different courts, changed by the Supreme Court. Supreme Court has interpreted the act in many different ways, and subsequent to that, many amendments have come. So it's an evolving law. It keeps on changing every day. So these are matters which are sub judice before the Supreme Court. Maybe once the answer comes, a final adjudication by the Supreme
Court. So we are almost out of time. So we will be entertaining one last question. We have Mr. Pradeep Noharia who wanted to ask a question. We are connecting him right now. Mr. Pradeep. Hello, Mr. Pradeep, if you can hear us. Yes, you may please ask.
Good afternoon, sir.
Good afternoon.
Actually, my question pertained to this amendment of the threshold limit, which has been increased up to 1 crore, and the proposed amendment for suspension of section 7, 9, and 10. Now, part of it has already been answered in response to another query. Now, the increase in threshold limit has been done pursuant to delegated legislation by way of a notification. The delegated legislation cannot be applied retrospectively. So can a view be taken that the cases which have already been filed before the date of the notification, they will continue with the old threshold limit, and the subsequent cases, the new limit applies? This is part of the question. And second is, what will be the position of suspension of section 7, 9, and 10? Will they be applicable retrospectively? If they are not made retrospectively, they have not made effective retrospectively, in that case, the old cases should be continued. I mean, this is a view which I'm expressing, which is a little contrary to what the learned senior counsel has just said, but I wanted his views on these.
See, to answer this question of yours, let me explain to you that, as I had said, the issue regarding the threshold limit of 1 crore from a particular date onwards is already now in operation, which is in view of the powers given under Section 4, that the government, the proviso to Section 4, which says that the central government by notification specifies a minimum amount of default higher value which should not be more than rupees 1 crore. So what the government has done, it has issued a notification as per Section 4, bringing it the preview to rupees 1 crore. As I had said, Mr. Noharia, earlier, and I again reiterate to say that, now that is an argument and submissions to be made before the court of law when the courts reopen, as to what about the cases which are already pending in the NCLT, which have not been admitted under Section 7 and 9, which are below rupees the threshold of 1 crore, whether they can be entertained or not. As I said, my view is that we would have to make submissions that they cannot be entertained because there will be classification between equals. If a particular creditor having a amount which is less than 1 crore cannot be allowed to be instituted a CIP process, then why should people who are already, whose cases are pending, should be allowed? Because they both have felt the same difficulty in the pandemic, COVID-19. The circumstances have changed, the arguments have changed, the things are different. So we'll have to see when the court reopens whether the court will like to proceed or not like to proceed, whether the government will like to come with some notification or amendment, because it's already come up with coming up with the notification to suspend the proceedings under 7, 9, and 10 for a period of 1 year, which is going to come very soon, as what we have heard. So therefore, in case the amendment comes to suspend the proceedings for 1 year, then the argument will be, what about the cases which are pending? Why could not they be suspended? Because they are facing the same problem. They are going through the same dilemma. Their payments are also being stopped. Their supplies are also being stopped. They are also unable to do the business. Their payments are not there. They are not able to pay their salary. All these 30, 40 difficulties will be brought to notice of the courts and the government to take a final decision.
I think we are already out of time, and I think we will end it over here. I'm sorry we cannot take more questions. And sir, thank you so much for the discussion and for just explaining the entire procedure to the lawyers. As you know, the reason why we did this seminar was because I feel as a junior lawyer, we need to know the basics before we go into the analysis and deep discussions on the subject. So I would like to thank sir again. I would like to thank everyone else for attending this. And
thank you very much, Amitabh. And I must tell, before we part, thank you the Bar Association once again. Thank you, Abhimanyu. Thank you, Amitabh, Rakesh. As also a message to all the young lawyers: don't neglect the NCLT. It's a huge and a vast jurisdiction. It's a jurisdiction where there's space for all. One case caters for about 10 different parties, 10 different lawyers. Many issues are cropping up every day. And to specialize in the IBC, a little price, it is not restricted to only the Insolvency Bankruptcy Code. You must read all ancillary relevant laws, enactments, Reserve Bank of India Act, Banking Regulation Act, Securitization Act, Recovery of Debts Due to Banks, Recovery Act 1992, Negotiable Instruments Act, Contract Act, etc., etc., Transfer of Property Act, Electricity Act. All these acts are Industrial Disputes Act. the workers' rights. You must read all of them because they're all going to be used and actually be decided by one forum, which is the NCL. Best of luck. It was nice being part of the webinar. Thank you very much.
All right.
With that, we come to a conclusion of this session. Thank you very much to both the panelists. Thank you to all the listeners and everyone who tuned in. In case anyone wishes to revisit this lecture, a recording of the same will be available on Tiwari and Associates. You may visit it and you may watch a recording of this from there. And thank you so much for everyone's participation. And we are certain that this helped everyone grow as a lawyer and understand the IBC much better. With that, we conclude the session for today. Thank you so much.
Thank you.